All right, everyone, please go ahead and take your seats. It's now time for our next conversation. But before we get started, anyone, just a quick round of applause if you're feeling energized for the next session. Thank you. That also helps me get everyone's attention, so I appreciate you taking the effort in doing that. Please welcome to the stage Professor Stavros Godinas, Professor of Law at Berkeley Law, to discuss disclosure strategies in a patchwork era.
Oh, how about the rest of the panel? Come on in. You just need me, really, but... Hello, everyone. Thank you very much. So last year, when we started talking with panels about collaborating on this, we had started with one event at HAS that had the HAS people, and I was speaking at a panel, and somebody realized I was a lawyer. And then all the accountants turned and said, we'll ask all the real questions to the lawyer. And when we had kind of a similar event in the law school, all the lawyers were like, well, this is a business question, so we need to ask this question to the business people. So this year we decided to combine. So that means that all questions are welcome. But this is the panel that focuses on different legal regimes. And the fact that we have a regulatory patchwork around the world on an issue that is kind of by definition the most global issue that's around. So that's kind of at the same time not surprising, but a little bit kind of depressing. But we'll try to figure it out because that's what lawyers do. We're used to dealing with depressing issues. I'd like to start by asking everyone on the panel to introduce themselves a little bit, and then we'll start unveiling the patchwork. Sam.
Hi, so I'm Sam Hushauer. I'm a counsel here in San Francisco at a global law firm, Freshfields. And I cover sustainability and regulatory, including also the tech industry and high tech. And with a global team of colleagues, advise quite a number of leading global brands and large companies on sustainability and including sustainability disclosure matters.
Hi, I'm Christina Wyatt. I'm Chief Sustainability Officer at Persephone. We're a carbon accounting software company. I think I was probably invited maybe partly because of Persephone, but more specifically because before coming to Persephone, I was at the SEC on a special assignment to work on the climate rule. And before that, I was at the law firm of Latham & Watkins working on climate and ESG issues.
My name is Verity Chager, and I'm a member of the International Sustainability Standards Board, and that is one of two boards within the IFRS Foundation. The other board is an accounting standard setter, and so together our nonprofit organization, which is a Delaware-registered entity, we create standards that help companies communicate to their investors, lenders, and other creditors. And using accounting standards and sustainability disclosure standards together creates a more complete general purpose financial report. And just for those of you who have never heard of IFRS Foundation, in the US there's US GAAP, generally accepted accounting principles, and pretty much everywhere else in the world there's IFRS accounting standards. And so we hope to follow in that same adoption path and make a consistent global baseline of sustainability disclosures through our standards.
Great. Thank you all very much for joining me in this panel. I'd like to start with Christina and ask you, Christina, to kind of set the scene for us and kind of explain to us a little bit the journey of sustainability standards and how kind of we evolved to this regulatory patchwork. It was a very quick evolution, but what got us here?
Sure, happy to. So it's funny that we're now talking about a regulatory patchwork. A few years ago, we were talking about just no regulation, and it was still a patchwork. So it was the voluntary framework patchwork. So I think that's probably evolution. I actually do think that it's evolution. So when I went to the SEC, the first thing that we did was to talk to stakeholders. So we talked to a lot of investors, for sure, but also a lot of companies, a lot of NGOs and others. And what we heard consistently was that this fragmented reporting landscape was not helpful, that companies were under a mountain of questionnaires from investors and other stakeholders, and that all of the different alphabet soup acronyms were not helpful. And so companies were saying, look, just give us a lane of travel, help us understand just what we should be disclosing. And investors, for their part, were saying, look, we really need to have more consistent, comparable information on sustainability topics, climate in particular, to help us to incorporate this issue in our investment theses. And so that's what we set out to do. We weren't acting entirely alone. We were talking with others in the international community. We were speaking with the IFRS Foundation before the ISSB was actually set up, and they were working hard with sort of the most important of those voluntary frameworks that had come together to come up with sort of a prototype standard that they ended up kind of gifting to the ISSB, and then the ISSB put it through its rigorous process to come out with its first set of standards, S1 and S2. And then, of course, the SEC came out with its climate proposal, climate rule, and then sort of bringing up the rear, California came out with its two laws, SB 253 and SB 261, which are climate disclosure laws. Now, where are we today? There is quite a significant, I forgot Europe, sorry.
I was about to say.
Europe also came out with the CSRD, the Corporate Sustainability Reporting Directive. Now, where we are today is the CSRD is in the process of being pulled back through this omnibus proposal that has just come out. The SEC rule is in litigation. There's no indication that it's ever going to see the light of day in this administration. And so we're left principally with states. California has its climate laws. We have New York, New Jersey, Colorado, and Illinois that have similar climate bills. And very importantly, and I'll turn, I'll let you speak to the ISSB and its important role, Verity, but incredibly important is the role of the ISSB in helping to drive disclosures that are consistent and comparable around the world. And there are some, I think, 36 jurisdictions around the world that are in the process of incorporating the ISSB standards into their own reporting requirements. So I think we've actually made progress. We've gone from very fragmented and voluntary to highly regulated, and now maybe we pulled back a little bit on the regulatory front with the SEC and Europe kind of backing off a bit, but we do have that common lane of travel that really does look quite similar. We can talk about that with the states and the ISSB standards.
Okay, so I think that's the overall picture. Thank you very much, Christina, for drawing it for us. And I want to kind of drill down on each one of these pieces. And I'd like to start with Verity. Verity, explain to us a little bit what the ISSB standards are and how they come into this picture of voluntary / mandatory / regulation, and how they contribute to unpatchworking the patchwork.
Great. So Christina gave a great foundational explanation of why we came to be. It's because the market was suffering from this patchwork of voluntary initiatives and frameworks and standards, and investors really needed comparable information, and not from company to company, but especially from company in one jurisdiction to a company operating in another jurisdiction, so that if you have a portfolio that's diversified and you have companies from all the major markets, You want to be able to pick the right automaker for your company, and you want to be able to compare the Japanese automaker to the German automaker to the US automaker and figure out which one has the best return risk profile for your risk-adjusted returns objective. So we knew that the capital markets needed information, that the common information needs of investors, the broad group of $200 trillion in public markets invested around the world, needed useful information. And so we were focused on making sure that was something that could be provisioned by standards, disclosure standards. So this means not telling companies how to run their business or what decisions to make. So we're not talking about performance standards. We're talking about how to talk to investors in every jurisdiction in order to access capital and access capital markets. So in 2023, we issued our first two standards. One is called General Requirements. We're not great at naming things with a lot of pizzazz, but IFRS S1 stands for Sustainability 1, and this has a lot of important features, including information that would be provided about governance, strategy, risk management, metrics, and targets. And for the sharp listeners out there, that's exactly the same format of the TCFD, and that's on purpose because we heard from companies and investors that the TCFD is a useful framework, not only for climate, but for all sustainability-related risks and opportunities. And that's another innovation we brought on top of the TCFD, is that we were not only talking about risks, which are absolutely important to every investor, but opportunities, because investors want to know where to put their capital to get upside, to grow that capital on behalf of their clients. So we required companies to tell information, material information, that means what would move the needle for an investor to decide, I want to invest in this stock versus that stock, about all the sustainability-related risks and opportunities, but not all of the possible things that could happen in the world, but the ones that are likely to affect a company's cash flows, its cost of capital, its access to capital over the short, medium, and long term. So we did a couple things there. We're framing it about long-term opportunity. We're framing it about long-term business cycles, but we're also framing it about upside and downside. And that's why we also included and required companies to think about what we call the value chain. And we don't call it the supply chain, because it's not only about the inputs that you get, the raw materials you get, or the other things that you get to make your widgets, but it's really also about distribution and your customers and the regulatory context in which you operate, your whole market environment for success and value creation and value growth. So all of this is baked into sustainability risks and opportunities in our S1. And then we have an additional standard that's also built on TCFD that focuses on climate. So for companies that identify climate as a risk or opportunity, and notice I'm not saying it's required for everybody, but we think it's pretty common enough that almost every company is going to identify climate as a risk or opportunity. We have S2, which is more specific guidance about providing information. And it's got greenhouse gas emissions in there. It's got lots of stuff about transition, risk and fiscal risk. It's got information about scenario analysis. And both standards include my favorite feature, which is something was mentioned in the earlier panels. When we're talking about measuring data and you're talking about performance metrics, some of that is useful. But what are companies doing about it? That's where the strategy comes in, the business decisions, the CapEx, the OpEx changes to your long-term operating model that are going to grow your value. And part of that is my favorite feature, which is the financial effects, which is how much is that going to cost you to achieve that success that you're telling your investors and prospective investors about.
So that's what I understand as the core kind of goal, or the core, if I wanted to kind of summarize the ISSB standards in a key phrase, it would be financial materiality, I guess.
We just call that materiality.
Yeah, or sure. I basically wanted to contrast it with double materiality, which is the kind of the applicable standard, let's say, in Europe, just so that I give everyone a broad sense of what the differences are that we're talking about.
Yeah, and I'll take you one layer deeper if you'll let me, is
Okay.
that impact information that makes a difference to an investor is financially material.
Okay, sure. I'm glad to hear it. So, so that's where the differences start coming about. So, Verity, we've talked a lot about how. So this sounds great, like investors want to know about it, but you mentioned that there are 36 jurisdictions in the world that are now following these standards. Can you tell us a little bit about how, first of all, what are some of these jurisdictions? And also, kind of now that you've seen the standards being applied at a national level as regulation, what have you learned from that experience? How does that affect kind of how you're thinking about standards in the future? And how do you see that experiment going?
Yeah. So we have 36 jurisdictions who have already passed laws or regulations or have announced plans to adopt laws or pass regulations to require companies in their jurisdictions to use the ISSB standards. And those jurisdictions are across the Americas, EMEA, and Asia-Oceania. So in the Americas, we have Canada and Mexico, and Chile, and Brazil, and Panama. In the U.S., we've always had a plan for voluntary adoption driven by investor demand. So investors, when they engage with their companies, and they can still legally do that, thankfully, even with SEC guidance coming out recently about 13G rules, when investors engage with their portfolio companies, they ask for this ISSB disclosures, and this is in their public proxy voting guidelines and sustainable investing guidelines, and elsewhere you can see it. But across EMEA, we count the EU as an adopting jurisdiction. We count them once, not 27 times, because we worked really hard with them to align on the climate requirements so that companies that are subject to CSRD can also use ISSB standards. As long as they use that joint interoperability guidance we co-wrote with FRAG to help companies do it the right way, that's a really key feature. But we've also got Turkey, we've got Switzerland, Jordan, Qatar, Nigeria, Zimbabwe, and then over in Asia-Oceania, I should mention UK also is on the list, and over in Asia-Oceania, it's Japan, South Korea, China is adopting ISSB standards, and then many others, Singapore, Malaysia, Sri Lanka, and Indonesia. So what you should hear from that is it's intercontinental, it's developed markets, and it's emerging markets. And in relation to the comments earlier about emerging markets, we know that not every investor has access to information. And so emerging markets that are adopting the ISSB standards are really seeing this as an opportunity to grow their capital markets by providing transparent, reliable, assurable information that's comparable, and it's really going to invite more investment into their markets.
So I wanted to ask one last question about ISSB, and I know we had this conversation both with Christine and Sam about how ISSB standards are affecting state laws in the U.S. And I heard some very interesting things from you guys, so please share.
Yeah, back to the idea that when we were drafting the SEC climate rule, when we were working with the IFRS Foundation, we were trying to find a common lane of travel that made sense. And we wanted to build upon what had been done before. And so that common lane of travel really looked like the greenhouse gas protocol for your carbon emissions reporting, and the TCFD, as Verity has really nicely laid out, as the framework that companies were already using to help them to organize their thoughts around how climate might manifest as financial risk or opportunity for their companies. So TCFD and the Greenhouse Gas Protocol are quite baked into the SEC rule that's dead, the ISSB standards, the EU's CSRD, particularly through that interoperability guidance, but then also California's SB 253 and 261. And 261 explicitly says, and 261 is basically the TCFD piece of the California legislation. 253 is the Greenhouse Gas Protocol. It says you have to disclose your scope 1, 2, and 3 emissions, and 261 is you have to disclose your climate-related financial risks and what you're doing about them. in accordance with the TCFD. It explicitly says that you can use your reporting to the ISSB in satisfaction of the California requirements. So it really explicitly and very deliberately tries to drive that sort of interoperability, reduce the fragmentation, and reduce the burden on companies as they prepare to report. The New York, New Jersey, Colorado, and Illinois bills all follow suit. They're going to follow what California has done. So there's really a drive to try to stay on that common lane of travel and continue with the harmonization that I think the ISSB is really driving around the world.
Yeah, I mean, just say, I think that's right. Though I think the devil is in the details, right? And so you're 100%. It says that in the statute, and currently CARB is in the process. California Air Resources Board is in the process of starting the rulemaking that will, because these statutes, the two California statutes, are quite thin. And CARB is launching a rulemaking right now to write the rules that will govern these disclosures. And they have a comment solicitation up, and there's 2 more weeks left on it if anybody in this room is interested in having their views heard. And they've asked a lot of questions about the nature of what these rules should look like. And the questions are just quite interesting to read if you're kind of nerding out on this stuff. But because they show that CARB is thinking about CARB and stakeholders that they've been talking to are clearly thinking about a lot of different permutations of what this can look like, and including one of the areas where they asked a lot of questions is on interoperability and on what it would look like. They're sort of soliciting input and views on like what it would look like to have rules that are responsive to California's needs, but yet track or relate to the kind of the ongoing maintenance of these international standards. And so I think that there's and they ask questions about like whether or not California should standardize aspects of the international standards, sort of looking at flexibilities that are built into the TFCD and to the ISSB in terms of reporting choices that companies can make under those, and whether in California we should standardize and require certain choices to be made, which could create some tapestry effects for people in terms of having to count numbers in different ways in different jurisdictions. So I think there's it's interesting. It indicates sort of direction of travel, as you were saying, towards the ISSB, but they're clearly thinking about how far to go that direction and whether they need to tailor things for California. So I'm curious also about the kind of the dialogue with FRAG that you've had and the joint guidance there. And sort of whether there are kind of things that you've learned from that process that and from the implementations in other countries that kind of bear on how we might think about in the 5th largest economy in the world, how we do the rules such that they actually do interoperate with the rest of the world.
I love, Sam, it's as if you got my memo that is the best question possible. I think interoperability is what we have to do when you develop two things separately, and then you have to try to make them work at the back end after the fact to make it not so costly for companies and burdensome and duplicative and all these other problems that are created. So I think the thing we learned is that having one international standard is easiest for everybody. And I think I know that's easy for me to say, being on the international standard side, but it also happens to be what UK thinks and Canada thinks and Japan thinks and South Korea thinks and China thinks. Not yet the US, but a lot of investors in the US, where most of the capital sits, think that also. And they have the global portfolios, and they're asking for this from companies all over the world. So what's best is to kind of have what we've called the building blocks model, which is being embraced in some markets, and that is having this baseline of aligning to the ISSB standards and then building on something that's unique and needed and special to the local jurisdiction. So that in Europe could look like, the baseline for investors, lenders, and other creditors, what Europe would call financial materiality, and then add on for Europe, which would be the impact materiality side, which is really important in the European context especially. In Canada, looks like starting with the ISSB global baseline and adding on specific additional disclosure requirements related to how businesses engage with Native indigenous populations and organizations, because that's really, really important for getting business done in Canada. And so there's additional incremental requirements there in this building block fashion. But I think bringing it back to California, what's been really helpful, we have conversations with regulators all over the world, including EFRAG and European Commission, and including California Air Resources Board and others here and around the world. And they're very much interested in making sure that this is feasible for companies and not overly burdensome. And so they're looking for ways to find these ways of efficiency. And so when the Greenhouse Gas Protocol allows a lot of variability and choices that companies can make, it's an opportunity for them to point to ISSB standards, which has narrowed the field to specific choices that can encourage comparability. And so, as you said, I'll just echo the call, the solicitations open until March 21st. These are laws that are already passed. So the question is not, should there be a law that requires these disclosures? The questions CARB is asking is, how can we make this most feasible for you to meet the law? And that's a really friendly invitation, I think.
So I wonder, you both alluded to how difficult it is for companies to decide how to comply with various rules and different regimes. So I wanted to bring this question kind of front and center. I've been interested in international financial regulation from before I became an academic. And this idea of kind of having a globally harmonized regime was always kind of the holy grail. But unfortunately, this is another area where we're far from it yet. So how are companies making these choices? How to comply, what to comply with? Do I comply with a different law in every country? Do I comply with one set of standards? How is this looking? Sam, I'm looking at you because you have the primary role of advising companies in that respect.
Yeah, so I think we're having a lot of conversations with companies about that very thing right now. As with the EU omnibus, there's a significant change happening to the expectations about reporting. And so I think a lot of companies are currently in the process of revisiting the strategies that they had decided on a year and a half ago in terms of how they were going to approach the reporting.
Can you describe the change a little bit so that it's clear for everyone?
Sure. I think one thing to talk about in terms of the CSRD for folks who aren't familiar with it is that there are options available for companies and a whole stair step of the way in which the reporting will hit companies. So beginning with large European companies, stair stepping to smaller European companies, and eventually to global group reporting, so the global multinationals. And one option that's been available under CSRD, or one approach that many companies have been thinking about, has been a voluntary global report that would satisfy the obligations of their European subsidiaries, while at the same time, reporting on the company as a whole. And so a lot of companies, go ahead.
Yeah. No, I just wanted to pause here because it's maybe it's the academic in me kind of jumping in, but it's that's kind of an effect that we've seen in other areas of regulation with European initiatives. Like in privacy, that's what happened. There was one set of rules that Europe applied, and eventually everyone else kind of, even voluntarily in other countries, decided to comply with this set of rules. But now we might be seeing something different.
Yeah. Well, I mean, I'd say the European rules were definitely designed to drag the whole rest of the world along behind them, right?
But will it happen? So that's what I wanted to underline.
I mean, I think that now between the new kind of risks in the U.S., which the prior panel was talking about, right? Don't need to get into it a ton, but there's a lot more risk associated with various disclosures in the U.S. And then the sort of the expected changes that are coming in Europe in terms of potentially less data points to be reporting on, downscoping of which entities will be subject to reporting because of changes to the thresholds. It's led to companies stopping and saying we need to reevaluate what the right approach for us is. Whether we need to consider a regional approach to reporting, a sort of a tapestry approach, because of things like tensions between the obligations that we face in Europe and the U.S. For example, in France and Germany, you've got in Germany, for example, under corporate law, you've got mandates on the number of women in boards, and you have and like in Canada, you have sort of diversity expectations, and including around indigenous peoples. So like in different jurisdictions around the globe, you have different obligations. Corporate subs will be under different obligations that may be in tension with some of the political crosswinds in the U.S. And so thinking about whether you want to have a global report that speaks on behalf of the company is now a little bit more complicated. I think it's always been a bit of a complicated trade-off, but initially one of your trades is like you think about, well, if we get to present a coherent, clear message on behalf of the company that speaks about the entirety of the company, and that addresses things like materiality at a company level. So we look at what are the risks and opportunities for the company, speaking globally and looking at what's actually matters to the company, what is actually material to a company with 60,000 employees globally or something like that, rather than what is material to a sub in a small country and in one small country in Europe. And so that type of kind of opportunity to tell the story on a larger scale, I think spoke to a lot of companies, as well as the kind of the cost benefits of thinking about trying to craft a global approach to the disclosure, and then also the kind of the liability risks of the more disclosures you have in the more jurisdictions you have with different accountants and different auditing standards and different jurisdictional requirements on how the numbers are produced leads to potential for disparity across all of these different reports, which is a thing that creates litigation risk. I'm a lawyer, right? You have lots of people waiting in the weeds on different sides of different issues and with different motivations who are reading these reports and comparing them together and using AI to crunch them and look for disparities and then can bring litigation on that basis. So for a variety of different reasons, like there are some significant advantages to having one clear global presence or report in that way. However, I think now companies have to weigh increased risks in different jurisdictions and increased risks of having a single report rather than having a report that's more jurisdiction specific.
Christina, thank you, Sam. Christina, how is this looking from your perspective? This choice between regional reporting or global reporting and kind of the effect of kind of new European rules. Because in Europe, on the one hand, and this was mentioned earlier, you have the CSRD, you also have an institutional structure like the EFRAG, which is a semi-regulatory body just to avoid technical definitions for now, that provides guidance about applications. On the one hand, you have some sort of an institutional buildup. On the other hand, the effect of the omnibus package was that there are fewer companies now that are going to be mandated into joining this reporting requirement. So how is this choice between global and regional looking from your perspective?
I tend to agree with Sam that, first of all, having different information out there in different places is just, it exposes companies to risk. And so, to the extent that it's feasible, and I think for many companies, this is sort of how they are set up to report in any event, reporting at the sort of parent level makes the most sense. And to the extent that these various different laws and reporting regimes can be harmonized, then the imperative for reporting different information in different places will be reduced. And so I think the approach taken in California with SB 261, where it explicitly will accept disclosures that are made pursuant to the ISSB standards, and similar type initiatives are really smart, because we really want to get to a point where, not to sound like a broken record, but where we harmonize those reporting requirements and eliminate the fragmentation to the extent possible, and reporting up to the parent level rather than separate subsidiary reporting, I think in most cases will sort of be the safest approach.
Great. Christina, you brought us back to what's California developments. And we're used to thinking of ourselves as leading the world. So let's continue with that theme. There was, what we discussed in our preparation, lawsuits that are currently happening in California regarding climate reporting. So I think, Sam, why don't you fill us in on that a little bit?
Sure. Yeah. So the California, there's sort of three major California reporting laws that were all signed in the same session. SB 253, which is the emissions, the GHG emissions reporting, SB 261, which is climate risk reporting, and then AB 1305, which is an anti-greenwashing bill that's actually the Voluntary Carbon Market Disclosure Act, which is much broader than what it sounds like. And two of those three have been challenged in court. And so the SB 253 and SB 261, the United States Chamber of Commerce and the California Chamber of Commerce and a couple of other groups have challenged that one in court. And where we are with that is that the judge dismissed several of the claims earlier this spring, and we are now proceeding to briefing on what's kind of the core claim of the First Amendment challenge to it, which is a challenge of compelled speech, arguing that corporate speech is being compelled and the balance is unacceptable. I think the briefing now on that is going to be due in the next during the course of April. So we might be able to expect a decision maybe in the summer, possibly. Depends how fast they decide to go with it. But I think one thing that is sort of interesting about it is that in teeing up the briefing, the judge had indicated that one of the reasons he was not granting the chamber's original sort of motion on the First Amendment claim was that he needed more information about the scope of the companies that would be impacted in order to be able to conduct a balancing of the kind of the impact on speech versus the kind of the need. And so I think that goes a little bit to the rule that's being drafted and the kind of the considerations that CARB may be thinking about in terms of the litigation risk around how broadly they scope the set of companies that are included. Because one of the questions that's open at this point and that CARB has been soliciting comments on is how they should write the definition for doing business in California, the nexus that triggers applicability of these disclosure rules. And so one of the questions in the litigation is, how broadly does it sweep? How many companies are involved? And is it just one transaction that gets you into this, or do you have to have some greater nexus to California? So I think we may see that the rule actually sheds some light on that and plays into the litigation.
Great. So we have about 3.5 minutes. So I decided to ask you the biggest possible question, because this came up in a lot of the previous panels. There was a continuous discussion about disclosure as a strategy. What we're disclosing, what we're not disclosing, should we be talking more, should we be talking less, how careful should we be, how balanced it should be. Is it really going to lead us to where we need to be? Is this, should we have jumped on the disclosure train 15 years ago and now it's too late? So there was a lot of conversation about disclosure as a regulatory strategy. Is it effective or is it not? Now, obviously, this is the biggest question ever, but you're looking at companies disclosing from a unique perspective, and I wanted to hear your thoughts about how disclosure of these types of concerns and risks is going on so far, and what would you like to see perhaps more in the coming years? We have about a minute each. Verity, starting with you.
Well, I think one of the earlier panelists said it's not just that more disclosure is better always, but rather more decision useful disclosure is what's needed and what's better. In fact, we're a market-driven organization, which means that it's in our constitution to require at every phase of our process in developing standards that are internationally applicable is to ask the market, is this applicable to you? You're a company, does this fit? Is it too hard? Is it too costly? Or is it actually information you could obtain? You're an investor, would this move the needle for you? Would this change the way you decide to invest in one company versus another? And investors tell us all the time, repeatedly, we have records of this, that they do not want companies to waste their time and resources in providing information that is not material to them and also not useful for the company's own board of directors to use to think about the long-term strategy or its own executives to think about CapEx or OpEx planning. So useful information, I think, is the way forward. You do not have to do 300-page report to put useful information out there. So I think the right sizing of disclosures is absolutely the direction forward, and I think that's a good thing.
I think the really positive thing here is the increased rigor that goes into the crafting of disclosures. And so applying the TCFD framework in the ISSB standards in these laws is incredibly important for purposes of giving companies a framework to think about how climate may manifest as material financial risk, thinking about their governance structures and how they're organized to address these risks, thinking about their strategies for addressing these risks and potentially opportunities, thinking about the metrics that they use to hold themselves accountable. All of that is being done within the company, regardless of disclosure, and that's driven by the regulations and the standards. And the rigor that's grown up around that is incredibly positive, because 5 years ago, what we had were companies just going out with net zero commitments saying who knows what. There was a lot of greenwashing. There wasn't as much information within the company about what they were saying. So I think what we've seen is now less actual disclosure to the world, but greater rigor within the company. And that's good, because companies really need to think about climate change as a business risk and opportunity before they start talking about what they're going to do about it.
I think what I've seen driving action decisions and kind of really high level conversations with companies is discussion or sort of increased transparency and liability risk around plans and targets. So between AB 1305 in California, which requires substantiation, public substantiation of net zero and carbon neutral claims and targets, as well as the climate transition plan obligation under CSDDD. I've seen companies having to really wrestle with, like, are we on track? What does our commitment actually mean? Counting that in billions of dollars of investment in clean energy that has to be purchased and in various jurisdictions where it may or may not be actually available, and trying to figure out, like, how they would actually actualize these words on a page. And I think that is actually driving real action and investment. And so I think that's quite there is power to disclosure, but I think those are actually quite short disclosures, but they have big power. And then, on the contrast, like, there can be voluminous. I have associates currently, like, cross-checking many forms of a particular company's CSR report against all of their different 10Ks and disclosures in various different jurisdictions, and it's a huge cost to do that. And so I think interoperability is really important, because people shouldn't underestimate what the actual cost of having a bajillion different disclosures is, because these companies actually do end up paying for a tremendous amount of work that goes into that. And we'd rather use that money, I think, probably not to pay me and my associates, but to invest in climate action.
Great. Thank you all very much. I'm so glad that I asked. But it's time for the audience to ask questions as well. So if there are questions, please let us know. Yep. Sorry, let me...
Thank you, and great panel, you guys. My name's Danielle Gisnicki, and I work with brands and investors on sustainability, many of whom are now... I had a meeting to present to an executive committee CSRD readiness on about a week and a half ago, last Friday, and so that meeting was canceled. And so I'm wondering, I'd love to hear from you all. What's your advice to companies who are, have spent all this time and money and taken quite seriously the CSRD readiness process and are now, anyway, having cold feet, having, existential questions otherwise. Thank you.
Well, I think like the current message is the stop the clock is probably likely, but there's a whole lot of legislative process that's going to be associated in Europe, with any actual substantive changes. So it's too early to actually know what's going to be on the other end of the sausage, right? Like there could be a year's worth of legislative process in front of it, and that's at the EU level, and then it has to be, of course, transposed, right? And there's also like current. Some jurisdictions have already adopted the existing CSRD, and so like there's going to need to be work to be done to fix all of that. So I think it's like it's time to pause, take a breath, have a look at what's happening, and think about whether you need to make strategic changes. But I think it's actually still too early to say what this is going to look like. Unfortunately, we're on the eve of compliance. And they have scrambled things, but that is just the moment that we're now in, and we have to figure out, how to move forward with it. I'd say our EU experts actually in the room, and I would direct you to her. It's for the latest and greatest, because it changes like literally by the minute.
But if I don't know if that's your view too, but it doesn't look like it's going to be an on-off switch. It's more likely that there's going to be ongoing reporting on other aspects. So it's not, there's no specific change that's so fundamental, I think, I would say. But, yeah. Yes. For Verity. You said that in the morning. I mean, you need to disclose your insider information.
Companies, you have the budgeting process, and so you've budgeted for a DMA for next year, and so what getting that back and forth really creates some hesitation for corporate sustainability budgets to continue. So I think whether you're complying with one and then all of a sudden you're recommending another, I think it makes you kind of as a sustainability practitioner look like you don't know what you're talking about. So I think I'm just sharing a little bit of like, yes, I get it, it makes sense, but if you're dealing with the budget for next year, it's hard to say like, oh, still give me this line item of cash, I still need it, and I'm going to use it for a totally different thing I haven't talked to you about as much, but I'm exaggerating, obviously, but just I
think other people, other people wanted to talk on that, so.
While she's moving the microphone, I'll just say it's not only a sustainability budget, it's a compliance budget at this point, right? So it's a much bigger discussion, and no one can hold any chief sustainability officer or advisor at the whims of a wholesale change in political winds across a region, not even a single country, which has led to this difference in Parliament, led to this difference in European Council, and then European Union and Commission. So it's just, it's bigger than you.
Juliane is my name, so I'm basically Sam's counterpart in Europe. And we get these questions a lot, as you can imagine. And I'm sorry for the mess in Europe, so don't kill the messenger. IFRS does help, and if kind of, as you just said, kind of you follow the ISSB standards for the time being, that does help you. But this is climate only, and CSRD is a lot bigger and covers a lot more issues than just climate, if you so want. There is no. First of all, it will take some time until we know how CSRD in the future will actually look like. So the stop the clock most likely will be decided hopefully relatively soon in the next, before the summer, put it this way, which will allow those countries who have transposed the existing CSRD to kind of change their existing law, because otherwise you will be in a situation where you would need to comply in, say, France at the moment. Although kind of the EU has stopped the clock, which is kind of a crazy situation. So hopefully this will not happen. And we are rather confident that kind of it will not happen. But then the next step is kind of on the substantive changes. And indeed, there's little knowledge so far, but most likely the data gathering will be a lot easier, because kind of there are tendencies politically at the moment where people say 80% of the data points needs to be voluntary and not mandatory any longer, which kind of would allow you to basically boil down your data collection process considerably. Double materiality is here to stay, so this will not change. And the ESRSs, most likely, which is a book, I don't know if most of you might know that, it's a real thick book, they will also be simplified. And therefore, there is no kind of easy answer, and a lot depends on where you are on the journey. So we have one client, for example, they finalized the DMA and are basically now in the process of gathering the data. And we basically told them, don't do that, because maybe you collect data now that you don't need in the end, at least not for that purpose. If you kind of find out that you need this or want this for any other purpose, fine, but for CSRD, it might likely not be necessary. If you are at the beginning of the journey, you might also just wait and see. So we have one client who has 400 employees in France. We told them, wait before you kind of start the whole exercise. If you are somewhere in the middle, it's a bit like wait maybe for a month or two until you have a clearer picture, because if the stop the clock actually is adopted, you will for sure then, well, most companies would need to do the reporting for financial year 27 instead of 25, which also implies that you would need to have another look at your DMA anyway, because your DMA in 27 would be different maybe than to the DMA in 25. So kind of don't get rid of all the people who were involved. Make sure that whoever is knowledgeable stays in your company, but kind of basically monitor the situation as we go.
Okay, I think we're out of time, so thank you all very much. And we really got a sense of the patchwork, didn't we?
Thank you.